All right, good morning, everyone. We're on the record on case CR 33-24-1819, State versus Fabian Hernandez. This is the time scheduled for sentencing. Mr. Hernandez is here appearing with counsel. Mr. Archibald, the state's represented by Mr. Wood. Mr. Wood, you've got a case agent there at the table with you. Would you identify them?
Yes, it's Detective John Long.
Could you spell the last name, please?
B-O-N-E.
Thank you. Is the state ready to proceed with sentencing?
Yes, Your Honor.
Is the defense ready to proceed, Mr. Archibald?
Yes, Your Honor.
All right, thank you. I'll go through some procedural history of this case first. I'll note that Mr. Hernandez, on September 24th of 2024, an information was filed by the state charging you with multiple offenses, including count 1, murder in the first degree. That contained a Part 2 weapon enhancement pursuant to Idaho Code 19-2520. Also count 2, a felony possession of a controlled substance, and count 3, a misdemeanor possession of drug paraphernalia. You pled not guilty initially to those charges at your arraignment on October 7th, 2025. And at that time you were advised of your potential penalties for those charges, your constitutional rights, plea options, and legal consequences of exercising each of those options. On December 16th of 2024, the court was advised you had reached a plea agreement with the state. That was filed in the case. Under the terms of that plea agreement, the state amended the charge of murder in the first degree to a charge of murder in the second degree. The state dismissed the weapons enhancement, the felony drug charge, and the misdemeanor paraphernalia charge. On that same date, you changed your plea to guilty on that amended charge of murder in the second degree. The plea agreement contained additional terms, including that the parties would have a stipulation between the state and the defense that the indeterminate portion of the sentence would be a life term of imprisonment. The plea agreement also had terms that the fixed portion of your sentence would be determined by the court, with each party free to make their own recommendations on sentencing, that you would receive credit for time served since your incarceration on these charges, and the state agreed it would not file any additional charges relating to an offense of trafficking in methamphetamine. The court notes that was a non-binding plea agreement, meaning the court will consider the recommendations in this case, but I'm not bound to accept those recommendations. After you pled guilty pursuant to that plea agreement to the murder in the second degree charge, the court ordered a report to be prepared which contains other internal reports attached, and that's the pre-sentence investigation report. That pre-sentence investigation report was filed in this case on March 13th, so a week ago, and that is a report the court intends to rely on for sentencing. So first I'll note that I have received a written objection to certain parts of the PSI filed by the defense. Mr. Wood, have you seen the written objection of the defense?
Yes, Your Honor.
All right. Beginning with the state then, on the PSI report, I'd like to get Mr. Wood's input as to whether or not you believe any part of the PSI needs to be clarified or corrected or altered before the court considers it for sentencing.
Outside of the objections filed by the defense, which I'd like to address when we take up that motion, outside of that, no.
All right. Mr. Archibald, you did file an objection to the pre-sentence investigation report. I do have that, and we'll consider that at this time for imposing sentence. Beyond what was filed on March 18th, does the defense have any further objection to any part of the PSI or anything that needs to be clarified or corrected?
No.
Okay. Mr. Hernandez, to be clear, did you have an opportunity to read through that entire report?
Yes, Your Honor.
All right. Let's take up the objections that were filed to the pre-sentence report, and then the court will rule on those before going forward. So, Mr. Archibald, if you'd like to present an argument in support of your objections to the PSI, I'll hear that at this time.
Thank you. My objections spell out the
3 areas of concern on page 13, the first full paragraph. Starting with IDOC records. We dispute that Mr. Hernandez had been involved in a gang. We dispute that he has, quote, a long history of violent behavior, mostly while he is under the influence of drugs. That's just simply not true. The criminal record shows a disturbing the peace charge from 2008 when Mr. Hernandez was a juvenile. Disturbing the peace is hardly a violent crime and should not be considered as such. And a juvenile disturbing the peace does not equate to a long history of violent behavior, as the reporter said in the report. And so a probation violation was never filed against him for violent behavior. A probation violation was never filed against him for failure to complete anger management classes. So that paragraph is misleading to the court. It's misleading to the parole board in the future when Mr. Hernandez applies for parole.
All right, on that first one, we'll take these up individually. Mr. Wood, what's the response from the state as it relates to part 1, which is page 13, first full paragraph?
Your Honor, I don't know if the whole first paragraph needs to be stricken. However, the state does not have evidence that this defendant was involved in gangs, and so I think it's fair that that be stricken. I guess how you define a violent crime could differ between individuals. He has been convicted of delivery of a controlled substance, and some people consider that a violent crime. The state certainly does. That may not be what's anticipated by the court, and also I'll leave that in the discretion of the court.
All right, thank you, Mr. Wood. Of course, the accuracy of these reports is paramount for the court to consider. I looked at the objection in that paragraph, and I guess the thing that I think supports the objection is the beginning part of the paragraph that says IDOC records show that Mr. Hernandez has been involved in gang activity, and there is no record contained anywhere in PSI that backs up that comment. In addition, the quote, long history of violent behavior, I agree with the defense, is not supported by the record here. And I have to go just based on what's on the record. I do find that entire paragraph is rightfully objected to and will be stricken by the court. So page 13, the first full paragraph, the court will strike and not consider the comments regarding any alleged gang activity or long history of violent behavior, and the court will sustain that objection, and the final PSI to be filed in this case will include that being stricken from the report. Mr. Archibald, if you'd like to move on to your next objection.
The next objection is on page 14, the next page. The last paragraph contains 2 objections. The second sentence references drug and anger problems. We absolutely agree that Mr. Hernandez has drug problems, but the anger problems, again, this murder charge that he's pled guilty to, as the reports show, was due primarily to drugs, not anger issues. And so the premeditation, the plan of an angry person is not present here in this case. So the evidence shows that Mr. Hernandez was under the influence of methamphetamine when this crime happened, and I don't think it's fair to characterize that as an anger problem. We certainly acknowledge that that he's guilty of second-degree murder, but not that he had a long-standing anger problem.
All right, Mr. Wood, the response from the state, please.
Thank you, Your Honor. The state does object to this request. We strongly disagree with that characterization of this crime. This crime was not due to drugs. The use of drugs is not a defense, and it's not a mitigating factor. This crime arose absolutely out of an angry confrontation between a mother who wanted to protect herself and her children from the defendant's drug use, and his anger over that, and him shooting her out of anger. So I think that I strongly object to any characterization of this crime as being committed due to drugs. And I think that that sentence is fine. I think through his IDOC record, where he did fail to complete anger management, I think that that substantiates the drug and anger problems language that's used.
All right. Court's considered the objection, paragraph 2, which is discussing a sentence on page 14 of the PSI referring to drug and anger problems. The court is going to deny the request to strike that from the PSI, finding that the report substantiates an anger problem as a component of what occurred here. And I'll note through some of the defendant's own comments about the incident on page 1, that he said him and the victim had been, quote, arguing about infidelity and drug use, and the court doesn't find a grounds to strike that portion based on other comments included and the failure to complete the anger management that Mr. Wood referred to also. So the court will overrule the objection, and that part of the PSI will remain as written, and the court will consider that. Mr. Archibald, do you have a third and final objection? And if you'd like to take that up at this time, you may.
Yes. That same paragraph, the next sentence, the third sentence in the last paragraph on page 14, the pre-sentence investigator reiterates what's known as struck on page 13, a history of violence and gang involvement. So the third sentence in the last paragraph on page 14 should be stricken as it was on page 13.
All right, Mr. Wood, any objection to striking that sentence?
Your Honor, based on the court's reasoning on the first objection, the state does not, or the first count of this motion, the state will not object to that, to the history of violence and gang involvement being stricken.
Okay, then the court agrees also that it's not substantiated in the record, so the court will strike from the very bottom of page 14, the last final sentence that says, quote, he has a history of violence and gang involvement, and his negative associations led him to engage in illegal activity. That sentence will be stricken, and the final filed PSI with those corrections will not include that, nor will the court consider that comment in sentencing today. So I believe that concludes the objections to the PSI. Are there any further objections to take up as it relates to the reports, Mr. Archibald?
No, Your Honor.
All right. Mr. Archibald, I'll just ask at this point, does the defendant wish to stand by his plea of guilty at this time?
Yes.
All right, next we'll take up then any evidence that may be presented in support of aggravation or mitigation by both the state and the defense. Mr. Wood, does the state intend to call any witnesses or provide any evidence at the hearing?
Yes, Your Honor, the state intends to call Detective Bond for the sole purpose of authenticating and putting into evidence the 911 call.
All right, if you'd like to call Detective Bowman, you can take the stand and have it placed under oath.
You do solemnly swear that the testimony you will give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, sir, if you'd be seated up there in the witness box. Mr. Wood, you can inquire.
Thank you, Detective. Can you state your name and spell it for the record?
John Bone, John Bone.
And what is your current occupation?
I'm a detective with the REXBURG Police Department.
How long have you been a detective?
A little over a year.
Have you been involved in the case of the state of Idaho versus Fabian Hernandez?
Yes.
What was your role in that?
I was the lead detective over the case.
Detective Bone, as part of your investigation in this case, did you listen to 911 calls that were made in regards to this incident?
Yes.
And Your Honor, I'm just going to ask, especially under the relaxed rules of evidence, that I be allowed to play a portion of this call for the detective to authenticate it.
All right, for authentication, Mr. Archibald, any objection to playing a section for authentication purposes?
Yeah, Mayor, we've received the 911 call, we've listened to it, so we're familiar with the content.
Okay.
No objection.
There's no objection, maybe, this is for authentication, I presume you're going to publish that if it's admitted, Mr. Wood, is that correct?
Yes, Your Honor.
Mr. Archibald, would there be an objection to publishing that, or should the witness continue with the authentication process?
Not for this hearing, no.
Okay. As I understand it then, Mr. Wood, if you'd just like to submit and publish the 911 call, and if you do wish to lay that foundation, of course, go ahead, but I don't believe there's an objection from the defense at this point.
Your Honor, if there's no objection, I'll just play it, and I'll play it through my computer speaker and hold this microphone to it.
Okay. I'll ask the clerk to ensure we're picking it up clearly on our recording also.
Is that in here?
I can't even.
All right, sorry to interrupt, but we need to make sure this comes through in the record of our audio. If there's a way, maybe you can either just get the microphone right up to the speaker so it goes through the system.
Yeah.
911, you have an emergency. What's the address?
Is that coming through?
That's really light, but I can hear it.
610 Lilac Street. Okay, what's going on? My dad's trying to shoot my mom. Where at? My house. He just shot her? Yeah, he shot her.
You know, I'm gonna...
All right, Mr. Wood, I'm going to suggest we're going to take a short 5-minute recess. I need to be able to hear this. It needs to go into the record, and I understand this is an emotional proceeding, and I'll allow a few minutes for people to gather their composure, but we do need to play this in a manner that the court can consider, otherwise I'll consider it in camera. But let's just briefly, I'll step off the bench. If everybody wants to maintain composure, I do want this played in hearing.
Okay, Your Honor, I was gonna ask if the court would prefer to hear it in camera, but.
No, I would just prefer to hear it in open court, but I do want to have it in a manner that I can fully consider without distractions. So I'm not blaming anyone for the way they're feeling to hear that again at this point, but I'll take a brief recess. Everybody please maintain your composure. Other than the defendant, if you feel like you can, I'll have you step out for a moment while that's played, and then we'll come back on the record.
All rise, please.
We're back on the record on case CR 33-241819. Mr. Wood, if you'd like to continue, you may publish that, and I would also suggest we state at this time how it's marked.
Your Honor, it's marked as Exhibit 1. We have put it into the court, the court computer. So if I can approach and push play.
Okay, and Exhibit 1 then will be published. It was admitted without objection previously. You can proceed, Mr. Wood.
Your Honor, the state has no objections for protective bond. That's the only evidence it intends to submit.
All right, Detective Bonley, you can go ahead and return the counsel table. All right, in terms of any victim impact statements, Mr. Wood, the court's received victim impact statements containing the PSI. Court notes the victim in this case is Ariana Ramos Chavez, who is deceased. The victim impact statements included in the PSI include a statement from Maria Ramos, the victim's mother, the two minor children, initials MB and BB, and the PSI also has comments from the defendant. But in terms of victim impact statements, does the state have any further impact statements to submit?
Your Honor, this time it's my understanding that there will be 3 in-person victim impact statements. One by the victim's oldest son, who right now I'll refer to as DB. One by her sister named Susie, and one by her mother, Maria Ramos.
All right. As I noted previously, if a minor is offering a victim impact statement, the court permits that, but I would instruct the media, please don't video or broadcast in any way visually the identity of the minor victim. Mr. Wood, if you'd like to indicate which order, is that the order you intend to call these people for impact statements?
Yes, Your Honor.
All right, then you can indicate who the first.
What's the value of a life? That has no bearing in our sentencing statutes in Idaho. So while that may sound, the soundbite of that may be popular, that's not the law. So what's the law? First-degree murder is the worst potential punishment in Idaho. We all know that. A minimum of 10 years, a maximum of death. This is not a first-degree murder case. This is a second-degree murder case. This also had indication that if we went to trial, we were going to ask for manslaughter. And manslaughter, the maximum penalty for manslaughter is 15 years. There is no life sentence for manslaughter. And what's the definition of manslaughter? Killing in heat of passion. So, by all accounts, this court has seen that there was an argument that resulted in a killing. So if this case would have gone to trial, that's what I would have been asking for, is manslaughter. But this isn't a manslaughter case because in mediation, my client didn't want to go to trial. He wanted to settle. From day one, he wanted to settle. And so the mediator, with the approval of the prosecutor, with the approval of Ariana's family, we settled on second-degree murder. So this isn't a first-degree murder where we see death penalty cases, where we see fixed life cases. This isn't a manslaughter case where the maximum is 15. This is somewhere in between. And in the 30 homicide cases that I've personally handled, I agree with that. I agree that this case is not the worst of the worst. And it's not the most justified either. And so, what do we do now? Well, we have a young father. My client, by all information, attempted to be a good stepdad to Ariana's 2 children. And then he was a good dad for his 2 children. And so, without his meth addiction, by all accounts, these reference letters that the court has received, he was hardworking, he was compassionate, he was kind, he was involved with his family. And so how do we punish him for what happened? He needs to be punished. And he's the first one who'll tell you that I'm here for Ariana. I'm here to get punished for what happened. And punishment is only one of 4 factors that the court considers. We also have deterrence. Do people who commit murder think about what happened to other people who commit murder? No, they don't. Not in my experience. Not in the 30 homicide cases that I've handled. People who commit murder are out of their mind. They're not thinking right. They're not reasoning. They're not being rational. Some outside factor is weighing on their decision to commit a crime. And sometimes those decisions are split second. Sometimes they're long planned out. And in this case, there's no indication by any accounts that Fabian planned to kill Ariana. And that's why first-degree murder has been reduced, because there was no premeditation. There was no plan. And so, by that factor, the sentence shouldn't be the worst of the worst, as if it was premeditated and planned. So people who commit these crimes are not deterred by what has happened to another killer, because that's not, when Fabian was under the influence of meth, when he was having an argument with Ariana, was he thinking, I better not go grab my gun, I better not shoot her because of what happened to someone else? That's what reasonable people think, that's what rational people think, but that's not what someone under the influence of meth thinks. So deterrence is one factor. Rehabilitation. The court has been instructed to consider rehabilitation. A fixed life sentence, a 40-year sentence, there's no point in rehabilitation in that kind of a sentence. There's no motivation for my client to get better in jail, get better in prison, because if he's going to die in prison anyway, what's the point of being rehabilitated? So a long sentence doesn't justify either deterrence or rehabilitation. What it justifies is punishment. And Fabian, again, he knows he needs to be punished, but a life sentence or a 40-year sentence is not justifiable in this case. The court needs to, the final factor, protect society. The society needs to be protected from people who kill people. And will Fabian ever kill again? And I believe the answer is obviously no. Because with the life sentence, he'll be on parole forever. He'll be monitored by a parole officer forever. And so we'll know if he ever relapses again. We'll know that because after his term in prison, he's going to be monitored. He's going to be supervised for the rest of his life. And that's why we agreed to a life sentence, because he wants that. I want that for him. His family wants that for him. And so a life sentence is not required under second-degree murder. The minimum has to be 10 years, but that can be suspended under our statutory scheme. The Idaho legislature has said for first-degree murder, the minimum is 10 years in prison. You have to serve that. There's no such requirement for second-degree murder. And so I could be asking the court for 10 years prison sentence to be suspended and be placed on probation. But I'm not asking for that. My client doesn't want me to ask for that. Because he knows, and I know, that he needs to be punished more than just probation. So the 10 years that is required under the statute, that's what we're asking for. He's been in jail 7 months. Over the next 10 years, we believe he should be in prison. And we believe during that time, he can take advantage of classes. He can take advantage of counseling. My client first tried meth when he was 13 years old, 20 years ago. So he's dealt with the meth issue in his life since he was a teenager. And he's done well sometimes, he's done poorly sometimes. And when this happened, he had completed his probation. And so he wasn't being monitored, he wasn't being supervised by the Department of Corrections. And he relapsed, and Ariana was sick of it. I don't blame her for being sick of it. And Fabian regrets relapsing every second of every day. Ever since I've met him, he has shown appropriate remorse. He has asked for a chance to be for redemption. So how can he make it up to his children? He's hoping his parental rights aren't terminated. The statute provides that they may be. He's hoping they aren't. He's hoping his family can still be involved with his children and help raise his children. He knows it's not grandma's obligation. He appreciates both his own mother and Ari's mother taking care of the children. He wants to be able to show his children that he can be successful again in life. So 10 years from now, if he's paroled, he'll be 43 years old. He'll still have a chance to get a job, provide financially for children. His children now are 1 and 10 years old, I believe. So he still has a chance to show his children how sorry he is for what happened. He has a chance to show them that he can be responsible. So that's why we're asking for a sentence, a minimum 10 years in prison, and we're in agreement with indeterminate life because we don't ever want him to relapse on meth. So that's why I believe that this sentence should be somewhere between a murder 1 sentence and a manslaughter sentence, and that's why we're recommending 10 years to life. Thank you.
All right, thank you, Mr. Archibald. Mr. Hernandez, as I previously indicated, you may address the court if you wish. This is known as the right of allocution, which permits you to make a statement on your own behalf or presenting information in mitigation of the punishment for the offense. You wish to make a statement to the court?
Yes, Your Honor.
All right, at this time you can make your statement, Mr. Hernandez.
I realize that today is not a court date for me, but it's a court date for Ari. It's for justice for Ari. I gotta pay for what I did. And I want to say that I'm deeply sorry to Ari. They can't wait to her. Nobody really knows how much I do regret my actions and decisions. I miss her every single day. And I hope one day she can forgive me. She was a wonderful mother, sister, daughter, and spouse. She valued her kids most because growing up, Ari had no mom or dad. No matter what anyone said, she fought the battle with me of addiction in hopes one day I'd change and leave it in the past. I won't forget her hard dedication to all 4 of her kids. Everything she did to make sure their dads were bad. I won't forget her beautiful smile, laughter, our good times, the times you waited outside of me rehab for me to finish with classes, how you taught me how to live a normal life and hold myself accountable. I miss your hugs and kisses, how you would show up with all the kids to the job site and bring me food. I'm sorry to all 4 of our kids. I took your beautiful mom away. They're not here mamas. She would be proud of you too, on how you shared your feelings and stood by her. I'm so sorry. I hope one day you two can forgive me. I love you guys. To my Lily boy and my Sitka party, I know I took mom and dad away. And I'm very sorry I put you guys in a spot you don't want to be in. I worry about you guys daily. I wish I could have gone to help with my addiction. I should have listened to your mom, Ari, and realized that all 4 of you cared for mom and me. I remember your mom saying, we got no friends in life. My friends and family are my kids and you. I'm sorry to Ari's family, especially to her brother Shoop and Larry, her sister Nana. She loved you guys so much. Growing up, you guys, that's all she had. I remember the story she told me about you guys. The Bronco, everything. Oh. I'm sorry to my family, to my parents, Bilal and George, my siblings, Karina, Vanessa, and Junior. I know Ari held a special spot in your heart. But the last person I'd like to plead with is with Ari's mom, Maria. I want you to know that all 4 kids are experiencing the most hurt, not just Sitka, Denzel, and you. In reading your statement, it would have hurt Ari. What you said about my parents, they just want to help you. They don't want to take those kids away. They love those kids too. Sitka and Denzel have lost both parents. I hope one day you really open up your heart to my kids and family. If you true motivation are my kids, I plead with you to allow my family to help you with my kids. 2 wrongs don't make a right. My family wants to help only, and they have. Hate me all you want. But show my kids love, no more trauma, please. I take accountability for my actions. My kids and family have no fault for what I've done. I hope one day you do see my remorse. I love and miss Ari, my kids, all 4 of you. I hope you're resting, Ari, my chipmunk guys. I love your justice for Ari.
Mr. Hernandez, thank you for your comments to the court. I'll consider those in sentencing. Mr. Hernandez, are you fully satisfied with the representation you've received from your attorney in this case?
Yes, Your Honor.
Thank you. Mr. Wood, is there any legal reason why I should not sentence the defendant at this time in the state's aware of?
No, Your Honor.
Mr. Archibald, any legal reason why the defendant should not be sentenced at this time?
No.
All right, thank you. Court's going to pronounce sentence at this time based on your plea of guilt on the plea agreement and a change of plea hearing. Mr. Hernandez, the court finds that you are guilty of the offense of murder in the 2nd degree in violation of Idaho Code 18-4003G. In considering sentence, the court looks at a variety of factors, including first your criminal history that's contained in the pre-sentence investigation report. It's been discussed here at the hearing. You do have a previous criminal history. You are 33 years of age according to the court's records. You had an offense charged in 2008 and adjudicated in 2009 as a juvenile. There was a driving offense in 2008 also, which was a misdemeanor. You did have your first felony conviction, a 2010 case where, as was mentioned, you received a sentence and were required to serve a retained jurisdiction period. And so that was quite some time ago in 2010. There was another misdemeanor in 2010 for a possession of paraphernalia charge. Then in 2020, another felony drug-related offense, and also a retained jurisdiction, as indicated, was served there. So those are the prior offenses the court considers. There clearly is a history of substance abuse that goes throughout the report, and it's been spoken of by both sides today. In addition to the pre-sentence report, the court considers recommendations contained in the PSI. Ultimately, the PSI recommends, quote, a lengthy prison sentence, suggesting that while you're in prison, you receive treatment for anger management and other relevant programming. There's also a substance abuse evaluation in the report, and it recommends a level 2.1 intensive outpatient services treatment for your substance abuse issues, and finds you do suffer from a severe stimulant use disorder related to your methamphetamine addiction. In addition, the report contains a psychosocial assessment under Idaho Code 1925-24, and that recommends, quote, medically monitored non-residential services for any mental health needs. In addition, the court has to consider not only that information I reviewed in the new report, consider the statements made here today, the evidence presented in the publication of the 911 call, statements of victims who made impact statements, and I've also considered those previously referenced letters of support and recommendation from your family, and of course, for comments to the court as well, Mr. Hernandez. The main factors the court considers in sentencing are out of a case State versus Toohill, 103 Idaho 565, and also codified in statute 1925-21. Protection of society, the primary objective. Deterrence of the individual and the public generally. Possibility of rehabilitation, and punishment or retribution for wrongdoing. 1925-21 also contains additional things the court needs to consider, and obviously in a homicide case such as this second-degree murder conviction, the court has to look at some additional factors that are set forth in that statute. Would a lesser sentence depreciate the seriousness of the defendant's crime? And that's a big factor. In this case, the court also looks at those factors under the statute. Would imprisonment provide appropriate punishment and deterrent to the defendant? Does imprisonment provide an appropriate deterrent for other persons in the community? And is the defendant a multiple offender or professional criminal? The court also considers mitigation factors, and those are set forth in the statute also and have been referenced here today. I'll note additionally, I mentioned your age, 33 years old, the LSI score, which purports to determine whether someone is likely to reoffend, places you in the high-risk category with a score of 32 on the LSI. Beginning in this case with what occurred, there's no factual dispute of what happened here. Mr. Hernandez, when you killed Ariana, you remained there. You essentially turned yourself into law enforcement. You came before the court. You were charged. You reached a plea agreement. And I will note that this case has progressed and proceeded about as quickly procedurally as a murder case could. And a lot of that is due to your acceptance of responsibility. You, I believe, are sincerely remorseful. You did not want to further traumatize these children who were present. by requiring contested hearings, including a preliminary hearing, a trial, or other hearings. And I've seen you in court many times. You've always been respectful of the court. You've always really shown genuine and true remorse. You've got people who are around you who support you, and it just makes the case all that much sadder that I think, other than what happens when you are using controlled substances, you're a good, productive member of society, and you have a good relationship with a good person. This incident, then, in terms of the aggravating factors, the 911 call, clearly it's traumatic to listen to that. The fact that you killed her with children there present is very aggravating to the court. The fact that you fired multiple rounds ensuring her death. I am disturbed by the fact that as a convicted felon, you didn't even have the right to possess a firearm. You had no legal right to even have a gun. And yet, you had a gun. You went and got a gun, you kept a gun, you kept it loaded, you kept it at the ready. You weren't ever supposed to have one. You had opportunities on probation after doing riders. You failed to follow the law. You continued using meth, which is continued felony behavior whenever you're possessing meth or buying meth or using meth. In terms of your supervision, you earned yourself a lower amount of supervision, and then said in your comments basically you were kind of living a double life because they weren't checking up on you that much, and you got back into your meth addiction and ultimately got released from probation. And then when that became a serious concern and problem, you got in an argument with Ariana, and you went and got that gun that you had no legal right to own, and you killed her in cold blood with children there present. So the aggravating factors really weigh heavily here for the court to consider that, and they far outweigh the mitigation, because while I think you've done everything you can do since this happened, what you did do can't be forgiven, can't be reversed. She can't be brought back. These children don't have a mother. And all of that leads the court to really seriously consider the recommendations of the state in terms of a life sentence here. And on the other hand, I'll note that through a mediation process, the state was willing to reach an agreement where you pled guilty to second-degree murder. This was an event, Mr. Archibald says he considers it a manslaughter-type behavior, but I think it was a killing in the heat of passion, but it was beyond manslaughter because you took the steps and effort to go get that deadly weapon, which again, you should never have even had possession of, and it was there at the ready, and that's why she's dead. Your decisions, not just what happened in the argument, but to obtain that firearm in violation of the law that you knew well, and that provided the means for this murder. So upon all those considerations, when I weigh those factors out, the court determines that, as mentioned by the pre-sentence investigator and recommended by the state, a lengthy term of incarceration is most appropriate in this case. And it's unfortunate, Mr. Hernandez, because you are a pretty young man, and I think you had much ahead of you to offer to yourself and society, but given the sentence you're about to receive, you've lost everything. And the court is going to sentence you to a fixed minimum term, 35 years of incarceration, followed by an indeterminate term of life, for a total unified sentence of life. Given the nature of that, the court is not going to impose a fine, but the court will impose the civil penalty under the statute 1953-07, which I believe is in the amount of $5,000. Court costs are assessed. I don't believe the state has made a restitution request. If there is a restitution request, advise the court. Mr. Wood, you are given credit for time served since your arrest on this case. The court's not going to impose any other financial obligation in terms of any other fines or costs. That is going to be the court's judgment on the sentence. Mr. Wood, do you have any questions, and or is the state requesting any restitution in the case?
Your Honor, the only restitution the state would have requested was for some lab tests. Given the length of the sentence, I don't think it's necessary to request that. They're small amounts, so we will not be requesting any restitution.
All right. Mr. Archibald, do you have any questions about the sentence?
No.
All right. Mr. Hernandez, any questions from you?
No, Your Honor.
All right, Mr. Hernandez, I want to advise you of some very important rights. You have the right to appeal from this sentence. If you believe it's in error, you would only have 42 days to file that appeal, and Mr. Archibald can advise you further of that right. You also have a right to seek relief from this judgment under Idaho Criminal Rule 35. You have 120 days from today to file that motion for reduction or correction of the sentence. If you believe the sentence is illegal or too harsh, you also may have rights under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the day your right to appear expires. Those are your appellate rights. The court will require the defendant to submit to a DNA sample by right thumbprint if that's not already in the records of IDOC. Mr. Archibald, do you wish to retain the copy of your PSI at this point?
Yes.
All right. If the state and defense wish to retain the PSI for any potential future pleadings, I'll permit you to do that. Keep those held in confidence, and at some point the court will collect those. Mr. Hernandez, you're hereby remanded to the custody of the Sheriff of Madison County to be delivered to the authorities of the Idaho Department of Corrections for execution of this sentence. That will conclude the sentencing hearing. I do appreciate the attendance and the way everyone's comported themselves during this hearing. We'll be in recess.
All right.